Hello, everybody. Welcome to our Goldwater Institute roundup of the Supreme Court and in its last term, which just ended very unusually for the Supreme Court after July 4th. I believe it's the first time since the 1970s that the Supreme Court has ever issued decisions after the July 4th holiday. And in that case, it was a case that had been an emergency case. It was argued after that, during the Watergate scandal. So this is a very unusual term. And some of the cases that we're going to be talking about are very unusual in the sense that they are very complicated and have a lot of really interesting clues about the direction the court is headed in and about what the justices themselves think about how law ought to be interpreted. Now, I want to pause here to thank you not only for joining us, but also for supporting the Goldwater Institute in all of its work. The Institute depends on donations from people who like the kind of work that we do and agree with the principles that we stand for, which are limited government, individual freedom, a constitutionally responsible government that respects people's right to lead their own lives in happiness and peace. And we can't do the work that we do, including this teleforum and our legislative and litigation and research work, without support from people like you. We know it's hard times out there right now, but we appreciate it if take a moment, if you approve of the kind of stuff that we're doing, to drop a few bucks our way and help us to keep the lights on in this difficult time. Now, we have I think it's 5 or 7 cases, I can't remember now, that John and I want to talk about. And so I'll start off with discussing what is probably the most controversial of the recent Supreme Court decisions, and that is the Bostock case, which involves the question of discrimination against homosexuals under the civil rights laws that prohibit discrimination on the basis of sex. That's the word that the statute uses. It prohibits discrimination on the basis of sex. And what the court said in this case is that that also includes discrimination against homosexuals, people who are married to people of the same sex, and so forth. And the reason why this is so interesting as a legal matter, I mean, aside from the controversy that the result led to, this is a really interesting case as far as jurisprudence is concerned. That is how it is that we interpret the law. Justice Gorsuch wrote the main decision, and then the dissent, of course, the primary dissent was written by Justice Alito, both of whom are generally considered conservatives. But they disagree about how you go about reading the law. Really, the essential difference between the two is this. Is it possible for the law to be written on one day by people who think that it means one thing, and then say 10, 20, 30, 50, 100 years later, we come along and read the same law and say, no, actually, all along it meant some different thing. And that is really actually a very difficult philosophical question. It depends really on how you think language means things. Do you think that language only means things because the speaker and the audience think it means that thing? Or does language refer to some objective principle in such a way that it's possible to be wrong about what you think your words mean? In other words, if I write out, say, a letter to a friend, is it possible for me to think it means one thing and for him to think it means that thing also, but it actually means something completely different? Is it possible for me to use words and say something different from what I anticipated? Personally, I think the answer to that question has to be yes. Language does mean something other than what the speaker and the audience might think that it means. And that strikes a lot of people as counterintuitive, but that is why lawyers spend so much time with language and why we have rules that say, for example, that if you write a contract and you mean it as a joke, it still binds you. If I were to write a contract with John and say, I'll sell you my car for $1, but secretly I'm just kidding. If I put in the contract that I'm kidding, if I write the contract out and he pays me $1, I actually am required to give him my car in exchange for the $1. So that the reason we do that is because we're trying to have an objective law that doesn't just depend on what people think it means, but actually means something on its own. And that's what Justice Gorsuch thinks. He says, it's true, when the people who wrote this law wrote it, they didn't anticipate it would apply to same-sex couples, but it does. Justice Alito disagrees with that in his dissenting opinion. He says, no, language only means what the speaker and the audience think it means at the time. And because nobody at the time thought that this anti-discrimination law would work this way, therefore it can't work that way. And that's a very deep, interesting, fascinating, if you're a lawyer, philosophical debate. And I really encourage you to take a look at, read these majority and dissenting opinions. One of the great things about Justice Gorsuch, one thing I really admire about him is he writes very clearly in a way that it is entirely possible for non-lawyers to understand. And so I encourage you to take a moment. You can look it up on the Supreme Court's website and read that opinion and read the dissenting opinion. See how you come out, because their arguments are really quite fascinating. Now I'll turn it over to John.
Thanks, Tim. It's Justice Kagan, of all people, said we're all textualists now. Do you think that's true in light of Bostock?
It certainly does look that way. Justice Kagan is, I think, the smartest, most interesting of the so-called liberal justices. And seeing her, really, these justices, all of them, are really sharp. And it's really interesting to read some of their disputes for that reason. I do think that originalism and textualism, these are terms that lawyers use for complicated and sort of subtly different ideas. I think we're going to see those two duking it out. I think what we're seeing now is a lot of conservatives objected to the Bostock case because they said, no, law can only mean what it was originally thought to mean. And I don't think Justice Gorsuch agrees with that. Justice Gorsuch is not an originalist if that's what originalism means. Of course, nowadays, it's like every time you look at a book or a law review, there's some new kind of originalism. I mean, half the liberals are calling themselves originalists now, and it's hard to keep track. So I don't know what the term is. But yeah, I do think that we certainly have come a long way from the day of, so-called living constitution.
Yeah, totally. It's just so fascinating how two dedicated, self-proclaimed textualists could come to such a different conclusion. So maybe we'll get some more questions along those lines from the audience. Before we get to questions, though, we got a few more cases to discuss, and I have the opportunity to speak about a really nice silver lining from this last term in a school choice case called Espinoza v. Montana Department of Revenue. So there, the court held that when the Montana Supreme Court applied its state constitution's what's called an anti-aid or Blaine Amendment provision to prevent religious schools from participating in the state's school choice program, it discriminated against religious schools in violation of the federal constitution's free exercise clause. So let's unpack that a little bit factually and then with a little bit of background. The state of Montana passed a school choice program that allowed individuals who donate to certain private school organizations or school tuition organizations to receive a tax credit for that donation. And then once the donation is made, the scholarship organization can turn around and award scholarships to students to attend private schools, including private parochial schools or religious schools. Interestingly, the state attorney general did not have a problem with this program, but the Montana Department of Revenue did. The Montana Department of Revenue believed that the program violated the state constitution's Blaine Amendment, and so it promulgated an administrative rule that prohibited families from using these scholarships from these school tuition organizations at religious schools, in religious schools only. So stepping back a little bit, the case was the state case, the Montana Supreme Court case was decided on the Blaine Amendment. For those who don't know, the Blaine Amendment is or was a failed U.S. constitutional amendment put forward by Senator Blaine. There's a lot of history about it. It was plainly rooted in anti-Catholic bigotry. But what the original Blaine Amendment sought to do was prevent any public funds from going to religious or sectarian schools or institutions. After it failed adoption in the U.S. Constitution, 36 separate states adopted a version of the Blaine Amendment as part of their state constitutions. So this was the issue that the Montana Supreme Court said that the school tuition program violated. So after the Montana Department of Revenue put its rule in place saying parents can't use these for religious schools, parents sued. They won in the trial court in Montana, but the Supreme Court reversed, as I indicated. Interestingly, the Montana Supreme Court, in my view, went pretty far out on a limb and not only said that certain portions of the program couldn't work, but they invalidated the entire tuition credit program, contending that because there was no mechanism to prevent aid from reaching sectarian schools in violation of the Blaine Amendment, the whole program had to go. So that was it. In the state court, when there is an adverse decision from a state court, parties can petition the United States Supreme Court for review on federal constitutional questions, which is precisely what happened here. And the petitioners argued, parents of students at religious school, at one religious school, argued that the application of the Blaine Amendment to prevent scholarships just for religious schools violated the Free Exercise Clause. The Free Exercise Clause protects religious observers against unequal treatment or laws that impose certain disabilities on the basis of religious status. This also includes, as a result of a recent Supreme Court case called Trinity Lutheran, disqualifying an otherwise eligible recipient of public funds solely on the basis of religious status. So here, applying Montana's Blaine Amendment to exclude religious schools solely on the basis of religious status, the Supreme Court held was subject to strict scrutiny. As many of our listeners might be aware of, strict scrutiny means strict in theory but fatal in fact. It's essentially the highest level of review for constitutional cases. In order for a government program or government action to survive strict scrutiny, it has to be narrowly tailored to achieve a compelling government interest. So here, Montana argued that it had a compelling government interest in what it characterized as greater separation between church and state than the federal Constitution permits. The Supreme Court rejected that argument and said that it is not compelling in the face of a violation of the Free Exercise Clause. Montana also argued, interestingly, that it had a compelling interest in safeguarding public education by preventing the diversion of government funds that went to support private schools instead. This is often an argument raised against various school choice programs. The U.S. Supreme Court said that that was not compelling because it was not appropriate that only religious schools and not other private schools would have to bear this purported burden of diverting funds away from government schools. And the court ultimately held, because the Montana Supreme Court had no authority to invalidate the tuition program on the basis of the free exercise provision, the court reversed and remanded. The court held that a state does not need to subsidize private education, but once a state does decide to do so, it cannot disqualify some private schools solely because they are religious. As a result of this, states are free to enact school choice programs that allow parents and their families to choose programs that will work best for their families, including if those programs involve education at a religious or sectarian school. We did have a couple of questions that we received prior to our program, but Tim, do you want to add anything?
Well, aside from the school choice angle, what I thought was really interesting about the case is what it suggests for religious freedom issues going forward in the broader sense. So, 1995, I think it was, the Supreme Court issued a case called Smith, where it said the Constitution doesn't give you any kind of an exemption from a general law based on your religious scruples. So to take an easy example, if they pass a law that says nobody's allowed to wear hats, then that would also require you to remove your yarmulke, regardless of the fact that you have a religious obligation to wear it. That's what the Supreme Court said. It was a decision written by Justice Scalia. It's generally considered conservative, but a lot of conservatives had objections to this. They said, well, religious freedom can be affected by these, even if it's not intended as discrimination, it can still be affected in a way by general laws that are non-discriminatory. And what does that mean for cases like, there was a famous case called Yoder from the 1970s about Amish children and whether the government could force them to school, even though the Amish had objections. And in that case, the Supreme Court said no. So that case seemed to give an exemption based on religious grounds against a generally applicable law that wasn't intended as a form of religious discrimination. So how do you balance Yoder on one hand versus Smith on the other? And you really can't. So what this case, Espinoza case, seems to do, if you read the language, is it really signals kind of a retreat from that Smith rule. And it suggests that not only are you entitled to sort of religious exemptions, but the way Justice Gorsuch talks about religious freedom in general in terms of your freedom of action as opposed to merely your freedom of belief, that suggests a real change in how the First Amendment is interpreted. Because if you go back well over a century to the controversy over Mormon polygamy in Utah, there was a very famous Supreme Court case that said the government can prohibit polygamy because that's not free exercise, the court said, because free exercise only is what you think. So the government can still prohibit what you do, it just can't prohibit what you think. Well, a lot of people have, and including myself, have criticized that harshly and said, nah, that's too narrow an understanding of what religious freedom means. And this opinion really seemed to retreat from that view. So it would not at all surprise me if we see, and we've already seen this in some of the lower courts, lawsuits that challenge laws against polygamy, for example, on the grounds that this is a form of religious freedom. I think that it's going to be really interesting to see how religious liberty cases come in the next 3 or 4 years.
Yeah, that's great. Agree across the board. We did have a caller who sent us a couple questions ahead of time. The gist of it was, what impact is this going to have in Arizona? So for our Arizona callers already, you may know Arizona has a very robust student tuition organization program and a very strong educational savings account, or ESA program, both of which have been upheld as against state Blaine Amendment challenges by our state Supreme Court. So, we're in pretty good shape there. This ruling shouldn't have too much of an impact. Unfortunately, there is one bad Arizona State Supreme Court decision called Kagan, which invalidated school vouchers. There, the court rejected distinctions between private and religious schools. It prevented aid to either. So, not certain Espinoza is going to apply in the voucher context, but probably doesn't really matter anyway, so long as our ESA program continues in force or grows or is otherwise effectual, as ESAs are in many ways a more comprehensive program than school vouchers. The other question we got, and this is kind of an interesting one, it'd be interesting to get Tim's take on this. The caller asked whether STO money, scholarship money, could be delayed by the result of something like a governor's executive order. As a legal matter, probably, I think, at least according to the governor and some others, probably most anything can happen by executive order at the moment. But I don't think that would happen as a practical matter. The way these STO programs work, it's a private organization that holds the funding that's already been donated. So if there's, for example, a delay to the school year, the start of the school year, or something like that, they're just going to hold on to the money and then release it once the school year starts, or release it to a recipient for alternative educational options, things like teleschool or things like that. So those were some of the initial questions we got. I'm sure we'll get some more in the question and answer session.
Yeah, I think right now, the governors, I think, are as much as possible looking for ways to make these alternative options available as much as possible. Certainly, they should be looking at that going forward for the rest of the year. Well, so another case that John and I were particularly interested in because we recently published a paper that kind of touches on some of these issues is the Daca case. It's called Homeland Security versus Board of Regents. And this was the case about, Daca stands for Deferred Action for Children of Aliens. And it's about the Obama administration's program of withholding efforts to deport children who were brought into the United States in violation of federal immigration law. And what happened, if you remember, was during the Obama administration, there was an effort to get Congress to pass a law that would deal with this problem. Congress failed to do so. So the Obama administration issued a 3-page memo announcing what they were characterized as an exercise of prosecutorial discretion, saying that the administration would decline to initiate proceedings against people who were here illegally. It's called DACA. There was actually 2 programs. One of them was DACA. The other one was DAPA, which was about the parents. So this was plainly illegal, what the administration did. It simply announced that it was declining to enforce the law. And the reason that that's illegal is because the Constitution requires that the president take care that the laws be faithfully executed. That's the literal language of the Constitution. What the Obama administration was saying was not that they couldn't afford it, or that it was too difficult, or that they had other priorities, but that they simply disagreed with this law, and therefore they were refusing to enforce it, which was clearly an unconstitutional act, in my opinion. Nevertheless, that was the policy that was adopted. When the Trump administration began, the administration tried to find ways to undo what the Obama White House had done. So it had issued a statement, a regulatory statement, which it's required to do whenever it adopts a new policy, explaining why it was going to undo this. And then it did that, and there was a lawsuit, and this went on all this time, and now I believe this is the 2nd or 3rd time it's been in front of the Supreme Court. And in this case, the question was whether the Trump administration lawfully rescinded the original Obama administration DACA program. And this is an issue of administrative law. And so it involves what we call the administrative state, or these regulatory agencies, and what kind of burden the government has to undertake when it changes these kinds of rules that aren't statutes. Instead, they're regulations that are unilaterally issued by the president and his subordinates. And the court said, no, what the Trump administration did was unlawful. And it gets a little complicated. Why? To me, the best decision was Justice Thomas's decision, where he said, in dissent, where he said, look, the original Obama administration program was illegal to begin with, therefore it can't be illegal to undo it. But it gets, the reason why the majority of the court rejected that, it gets a little complicated in the so-called Administrative Procedures Act, which is the federal law that dictates how regulatory agencies do their work. And that can get very complicated and silly sometimes. It sounds like a lot of dumb pencil pushing when you say, well, you have to open up for public comment for a certain amount of time and all this sort of thing. But given that in our perversive regulatory age, these agencies exercise an immense amount of power over our lives, following these rules is crucially important. And so in one sense, even though the Trump administration lost the case, in fact, only temporarily, because the case is going to go back to the trial court for another round of briefing and all that sort of thing. So it really amounts to just a delay. But even though the Trump administration lost this particular case, in one sense, it's a win, because I think it's really putting some more vigor into the restrictions on how administrative agencies operate. And that can be, I think there's a silver lining in that cloud. I mean, we've seen, just recently, we saw the Trump administration lost a case in the DC circuit, this is right below the Supreme Court, involving drug price rules. We've blogged about this a lot on our Goldwater Institute blog, which I hope you're all reading regularly. indefenseofliberty.blog is the site. Where the administration passed a rule forcing drug companies to state false statements in their advertisements, and the court said that's illegal, and it was illegal for procedural reasons. There's a good example of how, I mean, that court is made up entirely of Democrat appointees who typically, approve of administrative agencies and want to maximize their power. So I think, sort of the hidden benefit is to see that these courts' rulings, even though they might be against the administration, are still setting good precedent to rein in these administrative agencies. Do you think that John?
Yeah, I totally agree with the silver lining piece. It's really extraordinary the times we're living in where, it is not for the executive to make the law. It's for the executive to enforce the law. And as a result of the massive expansion of the administrative state at both the federal and the state level, you have these enormous policy decisions, things about immigration policy, drug prices that are not being made by Congress or state legislators, but are being made by an administrative agency that no one elected and that is accountable to no voter. And that's an enormous problem. And sometimes you get people that like the outcome of certain cases because of the particular outcome, or they like an administrative rule because of the administration that put it in place. But that's frankly all beside the point. None of these decisions should be being made at the executive level.
And not even just for the regulations. I mean, the APA applies to how regulations are made, but as I have written about how it's not just regulations, it's these things that are kind of like regulations, these guidance letters and memos and things like this. So, you're running a business, you get an email from some administrative agency that says, from now on, we're interpreting this rule as meaning such and such. I mean, it's really very arbitrary in how it works.
Yeah, 100%. Goldwater Institute represented a company that was trying to connect pilots and passengers so they could share flights on small planes. And the legal determination was made by the FAA and what the FAA called a letter of interpretation that had enormous consequences for the entire aviation industry, general aviation industry. And it was written by one person as a letter of interpretation. And that's just, it's just not the way things ought to work. So definitely agree with I definitely see a major silver lining in this particular court finally putting in some rail guards around what has been an exponential growth of the administrative state and legal acquiescence to that growth. So the last case I'll talk about, and then Tim has one more on his docket. Mine involves the issue of qualified immunity. And it was not an opinion from the court. The court decided not to take the case, but it involved a denial of certiorari and then Justice Thomas dissenting from that denial. So as our callers are probably aware, the U.S. Supreme Court is a court of discretionary review. When you want to get in front of the court, you have to ask it first to take your case. And the court doesn't have to. And in fact, it doesn't. In the vast majority of cases, it takes less than 1% of all cases that come before it. And this was one of those cases, but it raises some very, very serious questions around this issue of qualified immunity, which is beginning to get a lot more attention as a result of the George Floyd murder and some of the other instances of use of force that we've seen, particularly from police departments. So what is qualified immunity? So stepping back, individuals can sue the government and can seek civil damages against government officials under federal law, under what's called Section 1983 in Title 42 of federal law, if the government has violated an individual's constitutional rights. And those violations can include things like excessive use of force by police, privacy invasions, improper seizures, et cetera, et cetera. Section 1984, it's been amended several times, but it was originally put in place by Congress in 1871 as a response to violence by the Ku Klux Klan as part of what's called the Civil Rights Act of 1871. And it basically said, look, if there's a government actor acting under color of state authority, and that government actor violates your constitutional rights, you can sue him personally. Now, the text is pretty plain in terms of what it allows, but over the years, the courts have read into Section 1983 cases what's called qualified immunity, which is an affirmative defense that essentially allows the government a complete defense against civil liability unless the plaintiff can show that what the government did violated an already, quote, clearly established right. So what does that mean? That means in practice that a plaintiff has to generally point to some previously existing court decision on similar facts in order to get relief. So if you're the first plaintiff out the gate, even if the government's violated your constitutional rights, unless you can point to a similar decision, to something that shows that it was a clearly established right, you're going to be out of luck. Also, courts have read in a reasonable officer standard that essentially affords a good deal of deference to government actors. I shouldn't say reasonable officers; it doesn't just apply to police, of course, but reasonable government employee standard that allows a variety of deference to government actors and essentially shields their conduct unless it's very, very incompetent or unless it's a knowing, plain violation of the law. So this doctrine, this qualified immunity doctrine, has resulted in some truly outrageous outcomes. Last year alone, it shielded government from liability when police officers literally stole. They admitted, well, they ultimately found that they stole $225,000 from a person. Shielded them from liability because there's not a clearly established right there. It shielded police officers who shot a 10-year-old while trying to shoot a non-threatening family dog. Prison officials who locked an inmate in a sewage-flooded cell for days were shielded from liability. SWAT team members who fired gas grenades into an innocent woman's empty home were shielded from liability. A medical board who rifled through a doctor's client files without a warrant were shielded from liability under the qualified immunity doctrine. So the case that got up to the Supreme Court is called Baxter v. Gracie. And there, Alexander Baxter was in the process of robbing a house, and police officers released a dog to apprehend him, and the dog bit him. And Baxter alleged that he had already surrendered when the officers released the dog. So he sued and he sought damages under Section 1983 for excessive force in violation of the Fourth Amendment. Now, the Sixth Circuit said that even if the officer's conduct violated the Constitution, even if it was a Fourth Amendment violation, they weren't liable because their conduct did not violate a clearly established right. So Baxter petitioned the U.S. Supreme Court for cert. The court denied certiorari. Justice Thomas wrote a very interesting dissent, and he observed, among other things, that the doctrine of qualified immunity is completely judicially created. It has no basis in the text of the Civil Rights Act of 1871. That act makes no mention of defenses or immunities. Instead, it allows for civil liabilities if there's a categorical deprivation of constitutional rights of the plaintiff. And in fact, for over 100 years, there was no immunity that was read into that law. Case law kind of ebbed and flowed. It read into a subjective good faith determination. And then you ultimately kind of have the very broad qualified immunity doctrine that exists today. I think the takeaway from this denial of cert is that this issue is not going away. More cases are going to get up to the U.S. Supreme Court and into the courts of appeal that chip away at qualified immunity doctrine. Interestingly, I think there could also be some statutory solutions here. Senator Mike Lee and some other senators introduced federal legislation that would eliminate qualified immunity. I think the same could be done, certainly the same could be done at the state level with state level legislation.
Yeah, this reminds me of something a law professor once said about Brown versus Board of Education and those kinds of cases. He said, the law is not the cutting edge, it's the trailing edge. Typically, in order for you to win your case, you have to have already made your case in the court of public opinion. And so these kinds of qualified immunity things, like you said, they're not going away. And obviously, it's received a lot of attention this past summer. And this issue is we're just going to have to keep hammering away at it in order to get courts to really take it seriously, which they're very reluctant to do, especially state courts, because state judges are elected, and so they don't want to be seen as being soft on crime. And if you are going to resist or if you're going to try and change this area, you're going to be accused of being soft on crime and being pro-criminal and that sort of thing. But John, it struck me, actually, I hadn't thought about this until you were just now talking, how ironic it is that Justice Thomas would make the argument that qualified immunity is not found in the text of the civil rights statutes, when at the same time Justice Thomas is one of the leading advocates of the 11th Amendment immunity that prohibits you from suing, right, which is not in the text of the 11th Amendment. The 11th Amendment simply does not say that. It says you're not allowed to sue another state. And the court, in a case called Hans versus Louisiana in the 1890s, invented the idea that it also somehow prohibits you from suing your own state. And since then, that's what the court has consistently said. And Justice Thomas has been one of the loudest voices in favor of that idea. even though there's absolutely no textual foundation for 11th Amendment immunity in the Constitution of the United States. It's kind of frustrating to see when justices are inconsistent in that way, because a lot of the time at least it looks like it's done out of a political desire to prevent people from suing the state. These immunity doctrines, of course, you and I, we're plaintiffs' lawyers, so we hate immunity doctrines. We think, in fact, I think they basically undermine the most basic principle of the American Constitution, which is all men are created equal. If that's the foundation of our political society, and the idea of these official immunity doctrines is basically to say that there are star-bellied Sneetches, and then there are Sneetches with no stars upon theirs, and some people get treated differently than others in the law, and that's just and not only that, but our deputies. Government is supposed to be our deputies, and yet they're immune from suit by me. That is completely absurd. If I hire somebody to do a job for me and he fails to do that job, he can't turn around and immunize himself from my lawsuit. And yet that's exactly what happens in these immunity cases.
100%, and immunity is just like administrative deference and these other doctrines where the government gets a thumb on the scale when it shouldn't. And I think that's why so much of our work is.
I remember when I was in law school, I was first learning about the immunity doctrines, and I remember I had never heard of this stuff before, and I said, "You mean like James Bond? Because we have a license to kill, and that's what that is absolute immunity." Yeah. Well, I wanted to talk about one other case just very briefly, and that's the Oklahoma decision, which held that the eastern half of Oklahoma, basically, including a large part of the city of Tulsa, is Indian land that has never been abolished. And this is another example where, when we started out this conversation, we talked about the Bostock case, and in that case, I said Justice Gorsuch has this very objective theory of how the law works, that it means what it says, even if people don't think that it means that, or forget, in this case, what it means. And really, there's a real parallel here with this Oklahoma case, because what he says is, there was a treaty that said this land is Indian land, although technically it didn't use the word reservation, but it's the same thing. And then that was never eliminated, that Congress never passed a law to abolish it or anything. But what happened was that throughout the course of the 20th century, it just sort of got laid aside by government officials and by private parties who started moving in and building things like the city of Tulsa, until basically it was largely forgotten by the courts that this was even Indian land. And that's basically Justice Gorsuch's theory of the case. He says, unless they pass a law, it's still Indian land regardless of the centuries worth of changes that have occurred. And I'm very sympathetic to that. I think as lawyers, we have to take seriously what the text of the law says. And if the text hasn't been changed, it might look like a technicality, but we should follow that text unless there's really strong reason not to. And I think I'm really sympathetic to Justice Gorsuch's view that there are not such circumstances in this case. However, that said, I think there's some real costs, some real downsides to the results of this decision, and that particularly affects our work involving the Indian Child Welfare Act. We have a project here at the Institute called the Equal Protection for Indian Children Project, which focuses on the Indian Child Welfare Act, which is a federal law passed in the 1970s that more or less prohibits the adoption of children by non-Indian families if those children are genetically eligible for tribal membership. There's a lot of unique things about ICWA. One of them is that it has this eligibility rule. It's not a law that applies to tribal members. It's a law that applies to children who are eligible for membership in a tribe, and eligibility depends entirely on the blood in your veins. And so as a result, ICWA basically prohibits Native American children from being adopted by Black, Asian, white, Hispanic, or families of other races. And the reason why the Oklahoma case matters is because this law treats cases differently based on whether the child lives on a reservation or does not live on a reservation. If you live on a reservation and you're subject to ICWA, the tribe's courts get to decide your child welfare case, like your foster care case, your adoption case, whatever. And they have exclusive authority to do that. If you don't live on a reservation and you qualify as an Indian child, then your case goes to state court first, and then the state court is supposed to send it to tribal court unless there's good reason not to. But what this Oklahoma case ends up doing is it shifts a large number of children from one category, not on reservation, to another category, on reservation. And as a result, it deprives those children of the opportunity to argue in court that their case should be decided by a state judge instead of a tribal judge. And the reason that that's important is because the Bill of Rights does not apply in tribal courts. There is an Indian Civil Rights Act, which is a federal law that says tribes are required to accord the rights of the Bill of Rights. But unfortunately, in the 1970s, the Supreme Court basically nullified that law in a case called Santa Clara Pueblo, which is completely wrong, but unfortunately the justices have not shown any inclination to undo it. And so as a result, children who otherwise would have gone to state court where their cases would have been decided in accordance with the Bill of Rights now have to go to tribal court where there's really basically no federal guarantee of their civil rights. And that's a real downside. Another big problem, of course, even aside from the child welfare case, is that because the tribe has criminal jurisdiction, now a lot of people who have been prosecuted under the state's criminal jurisdiction, they're all going to be filing habeas corpus petitions. I saw some lawyer friend of mine put on Twitter his sympathies for all the judicial clerks who are probably chugging vodka at the very thought of the number of briefs they're going to be getting in the coming weeks seeking release because they were tried by a state court when they should have gone to tribal court. It's really going to be a mess. And Justice Gorsuch, in his opinion, basically says, yeah, I know it's going to be a mess, but Congress is going to have to figure out how to solve it. And that is really going to be something to see. Again, it's a decision that I think is probably defensible on legal grounds, but as a practical matter, boy, it's going to have some real messy and I fear possibly tragic consequences coming down. Anyway, so that's the Oklahoma case. And why don't we take a look at see if we've got any questions.
All right, it looks like we got one here. Let's see. I'm interested in what the Indiana confiscation case says about the court's thinking around state power, whether incorporation is now a settled issue, and if you might have heard how the Indiana Supreme Court might have reacted to effectively being called totally deaf. You want to take that, Tim?
Well, I think this is probably a reference to the case about the excessive fines clause of the Eighth Amendment. So, there's a principle that's typically called incorporation, which says that the Bill of Rights applies to the states. They're incorporated to the states through the due process clause of the 14th Amendment. Fun trivia question. The very first constitutional right that was incorporated against the states was? John, do you know?
I don't.
It was the right to compensation when your property is taken away in a case called Chicago B&Q Railroad. But most people overlook that nowadays, and they say that it was free speech or something like that. It was only in the 20th century that the court started using the term incorporation to refer to this. And they've done it on a case-by-case basis. But they had never got around to a couple, and one of them was the Eighth Amendment's excessive fines clause, which prohibits the levying of excessive fines. The court had never said that states are required to obey that rule. And in the Indiana case, they said that states are required to, and that case has now been remanded to the Indiana courts to apply. So that was a real win for constitutional rights. Ultimately, how the Indiana court would have reacted to being called effectively daft, I make it a practice as a practicing attorney not to directly call any judges daft. So
all right, let's see here. We got another question. Do we also see a trend towards scaling back limited immunity, as we recently saw, I believe, in either West Virginia or Kentucky at a lower court level? I think most immunity doctrines are going to be up for teeing up some cases on. I think if ever there was a time for these sorts of challenges to different immunity doctrines to be brought, is probably now. And I don't think people should also be shy about pursuing legislative options in addition to legal options that would eliminate immunity doctrines, and that can be rooted in the plain text of statutes that already exist.
Yeah, I agree, and in fact, I would say that legislative solution is probably the only real solution in the long run. Unfortunately, I'm kind of skeptical that the judicial branch is going to take much of a lead on this issue. For one thing, the judges themselves enjoy immunity. There's judicial immunity that says you're not allowed to sue a judge for even for some pretty shocking things. And the courts have invented these doctrines because, honestly, John, it's such a mess. This whole area of law has been a complete mess for a very long time. And in trying to fix one mess, they've ended up making another mess, and then they try to fix that mess, and they end up making another mess, and you end up just with the court going like this and never getting the law right, but just sort of heading in vaguely the right direction. And there's a great book called The Bill of Rights by Akhil Amar that talks about how the search warrant requirement was originally intended. Originally, if the cops showed up and searched you and they didn't have the authority to do so, you would sue them for that. And then the question over the validity of the search would be resolved in that lawsuit. And instead, we've shifted to this thing about the admissibility of the evidence and a civil rights case and immunity doctrines and things, which was not contemplated at the time the Constitution was written or the 14th Amendment was drafted, or even pretty recently. So this is such a mess. I just don't see judges ultimately cleaning it all up. And if they do, they're going to start with these police immunity doctrines in some extreme case like the George Floyd case. But when it comes to stuff like, the immunity doctrines even apply to high school principals who censor the free speech rights of their students. I just don't see a judge coming in and saying, we made a mistake, we're going to get rid of immunity in that area. I wish they would, and if they took that step, I'd applaud them for it, but I don't know, maybe I'm too cynical.
Nah, you're probably right. And the legislative path is the appropriate path anyway. The courts are the ones that messed it up, but legislatures can get back in there and fix what has been undone. Let's see here. Caller's concerned that in the event there is legislative changes, are school choice programs in the state of Arizona threatened? And is there anything in the Espinoza ruling that protects the state school choice program as is? What Espinoza says is that to the extent any government rule discriminates against a sectarian or religious school, it's not going to be upheld. So if you had a superintendent or a new governor or even a new legislature that wanted to prohibit aid to simply religious schools, actually the legislative question would be a more interesting one, but if you had the executive or superintendent try and do that, I think that those sorts of decisions would certainly be protected under Espinoza.
I agree with that, but I can see that there might be a ground for this person's concern, and that is Espinoza has this one thing I thought was weird, John, is that the decision talks about religious status of the schools, and I think Dissent points this out, that what exactly does religious status mean? Because the majority still says you could prohibit the school from spending taxpayer money on religious activities. Well, drawing that line between religious status and the religious activities of the school could be pretty tough. And I would not be surprised if we saw some states, even if they do it in good faith, but states trying to draw that line but ending up stepping on some toes in doing that. And I can see that being a real problem going forward.
Yeah, that was interesting. What the court said is, look, the reason that this violates the free exercise clause is because the state is discriminating against what the school is, that is a religious school, rather than what the recipient of money might do with the money. So in the other case where the court said it was not a problem when public funds were used for somebody to do essentially religious training to become a priest or something like that. And you're right. I think that distinction could probably get hairy pretty quick, and there could be some.
And it puts us back in those cases from the 70s, like, what was it, Epperson versus Arkansas, I think it was, about whether you can spend state money to buy geography books for a church-run school, and the answer was no there. But then I think it was Zobrist said you can pay to bus the kids to the religious school, and it starts getting to sounding arbitrary, and the judges sound like they're just making that stuff up when you get down to it. I do worry that we can be headed in that direction with that sort of thing.
Yeah, I think that's fair. Anything else in the school choice ruling that have potential to negatively impact Arizona? What do you think, Tim?
I didn't think so. I obviously agree with your interpretation, and I thought I looked back at the case about the ESA program, and the court in that case was very careful to distinguish the school choice program in a way that said it's not a Blaine Amendment thing. And so because this case involved this Blaine Amendment issue, I don't see this case directly affecting that. Now, of course, every case affects every other case to some degree, so it's possible, but I just don't see a direct effect there.
All right, our last question here, also pertaining to school choice: can a president's executive order upend protections Arizona has in school choice where funding and policy requirements are concerned? Boy, we're hearing a lot of talk around this, particularly around funding for public schools, and the federal government's authority on this is going to be much more limited than the state government's. Right now, it's my understanding that school districts only receive at most about 10% of their funding from the federal government. So I think that it's going to be hard for the federal government, the president or otherwise, to have a whole lot of direct legal impact here. Although, of course, I think there's a separate question as to whether coming out and saying things like schools are going to open, school choice programs aren't going to be impacted, whether that will have a practical effect of encouraging the things that the president wants done to happen. But usually the federal government uses the power of the purse to kind of move the states in this area, and it's kind of limited in this case.
Yeah, that's true. But, also this goes back to what we were talking about the Daca case, that, remember the Obama administration was issuing these guidance letters that were affecting, interpreting discrimination laws in a way that was affecting how schools could operate. And so that regulatory authority, or pseudo-regulatory authority, where what was it, President Clinton used to say, stroke of the pen, law of the land, that in a lot of cases it can come down to that. That's why that is why stuff like the Daca case, with its restrictions on how the regulations can be enacted, is important, not just for things, immigration, which is controversial enough, but you're talking about these agencies that can affect everything, including how schools operate. Incidentally, there was a quote in the Daca case that I meant to mention, which really warmed my heart when the court said, there's a very famous line, Justice Oliver Wendell Holmes. Any of you who know me know he's probably my least favorite Supreme Court justice. Holmes once said, citizens must turn square corners when dealing with the government. And the court in this Daca case says, quote, government must turn square corners when it deals with the people. Exactly how it ought to be. It's we who are protected against the government. It's not the government protected against the people. And a rigorous discipline when it comes to how administrative agencies work and how regulations work is really essential to protecting us, including in the environment of how private schools operate.
Holmes must have been the nemesis in V for Vendetta, right? Where he said the people should not fear their government, the government should fear the people. Well, I think that is it. We are right at the hour. I want to thank everybody who called in for their review. Appreciate very much your interest in these issues, some of which we know can be esoteric. And of course, appreciate, as always, your generous support for all the work we do. So thank you, Tim, for your expertise as always. We're very lucky here at Goldwater to have Tim, who's one of the finest minds in the country on many of the issues we discussed today and many other constitutional issues. So,
and John, handsome man.
Just the lighting. Thank you all.
Thank you all.